la Gruppen International Øvigt. Please visit it. Veuillez vous asseoir.
Good afternoon. Would the court officer please call the case?
Good afternoon, Mr. President. Situation in the Bolivarian Republic of Venezuela I, situation reference ICC 0218, and for the record, we are in open session.
I am Judge Marc Perrin de Brichambault, presiding in this appeal arising from the situation in the Bolivarian Republic of Venezuela I. My fellow judges in this appeal are Judge Piotr Hofmansky, Judge Luz del Carmen Ibanez Carranza, Judge Solomi Bossa, and Judge Gocha Lortlipanidze. May I ask the parties and participants to please introduce themselves for the record, starting with the representatives of Venezuela, whose appeal we are deciding today.
Good afternoon, Your Honour, and to all those inside and outside of the courtroom. The Bolivarian Republic of Venezuela is represented today by Mr. Larry de Vaux Marquez, the state agent before the International Human Rights Mechanisms, the ambassador here in The Hague, Hector Constan Rosales, by myself, Ben Emerson, as legal counsel, together with my colleagues, Venkateswamy Allegendra and Aitor Martinez Jimenez.
Thank you very much. Could the Office of the Prosecutor please introduce themselves?
Good afternoon, Your Honour. Appearing on behalf of the Office of the Prosecutor, Merito Reggae, Appeals Counsel, Nevada Thuru, Associate Appeals Counsel, Cara Pronk Jordan, Senior Legal Coordinator, Alice Zago, Head of the Venezuelan Unified Team, and I'm Helen Brady. I'm the Senior Appeals Counsel. Thank you.
Thank you very much. Could the legal representatives of the victims, OPCV, please introduce themselves?
Good afternoon, Mr. President. Victims in this proceeding are represented by the Office of Public Counsel for Victims. Appearing today in courtroom, Mr. Enrique Carnero Rojo, Legal Officer, Ms. Ludovica Vetruccio, Legal Officer, Ms. Ana Peña, Case Manager, and myself, Paulina Massidda, Principal Counsel.
Thank you very much. Today, the Appeals Chamber will deliver its judgment in the appeal on the Bolivarian Republic of Venezuela against Pretrial Chamber 1's decision of the 27th of June 2023, entitled Decision Authorizing the Resumption of the Investigation pursuant to Article 18.2 of the statute. I shall refer to this as the impugned decision. This is a non-authoritative summary of the Appeals Chamber written judgment in the appeal. The written judgment will be made available and notified at the end of this hearing. I will now briefly explain the background of this appeal. On the 16th of December 2021, pursuant to Article 18.1 of the statute, the prosecutor notified all state parties of his decision to initiate an investigation in the situation in Venezuela. On the 16th of April 2022, the prosecutor received from Venezuela a request for deferral of his investigation on the basis that Venezuela is investigating or has investigated its nationals with respect to alleged punishable acts. On the 4th of December 2022, the prosecutor filed an application to the pretrial chamber requesting it to authorize the resumption of his investigation into the Venezuela situation. On the 27th of June 2023, the pretrial chamber rendered the impugned decision in which it authorized the prosecutor to resume the investigation into the situation in Venezuela. On the 3rd of April 2023, Venezuela submitted its notice of appeal, and on the 14th of August 2023, its appeal against the impugned decision. In the course of these appellate proceedings, the appeal chamber received written submissions from the prosecutor and the Office of Public Counsel for Victims, as well as representations from victims and observations from the Organization of American States Panel of Independent International Experts. On the 7th and 8th of November 2023, the appeals chamber held a hearing during which representatives of Venezuela, the Office of the Prosecutor, and the OPCV made oral submissions, including on certain issues identified by the appeals chamber. In its appeals brief, Venezuela raises 6 grounds of appeals. First, Venezuela submits that the pretrial chamber erred by imposing on Venezuela the burden of proof and by accepting the prosecutor's notification of his intended investigation, despite its procedural shortcomings and insufficient specificity. Second, Venezuela argues that the pretrial chamber erred by exclusively relying on the English translation of selected case files and failing to require translations of information concerning domestic investigation that was in Spanish, and to examine English translations of summaries of proceedings of records. Third, Venezuela submits that the pretrial chamber erred by relying on the temporal jurisdiction of the situation referred to the prosecutor by 6 state parties. Fourth, Venezuela argues that the pretrial chamber erred by finding that it was necessary for domestic investigations to cover contextual elements of crimes against humanity, discriminatory intent, and sexual and gender-based crimes. Fifth, Venezuela submits that the pretrial chamber erred in law in its complementarity assessment by relying on irrelevant factors while failing to give any weight to relevant factors. 6. Venezuela argues that the pretrial chamber erred by excluding national proceedings from its determination on the basis that there had been delays and periods of inactivity. Venezuela requests the appeal chamber to reverse the impugned decision. The appeals chamber's judgment, which I will now outline, is unanimous. As I shall set out in more details later, the appeals chamber has found it appropriate to confirm the impugned decision. Under the first ground of appeal, Venezuela submits that the pretrial chamber erred in law by failing to impose on the prosecutors a burden of persuasion to demonstrate that the cases investigated by Venezuela did not sufficiently mirror the prosecution's investigation. In this regard, the appeals chamber recalls its recent ruling in the Philippines judgment that, I quote, "The burden of providing information relevant to the pretrial chamber's determination under Article 18.2 of the statute remains on the state seeking deferral." End of quote. The appeals chamber finds no convincing reason to depart from this ruling. Venezuela also argues that the pretrial chamber erroneously characterized the additional information provided by the prosecutor as a second Article 18.1 notification and relied on it to assess the scope of the prosecutor's investigation. The appeals chamber finds no error in the pretrial chamber's findings in this regard. In light of the purpose of such additional information stipulated in Rule 52.2 of the Rules of Procedure and Evidence, it is not, in and of itself, an error of pretrial chamber to rely on such information as if it were part of the prosecutor's Article 18.1 notification, to the extent that such information complements and clarifies the information already provided in the prosecutor's notification. Venezuela avers that the prosecutor's additional information does not meet the requirements of notification as it sets out alleged criminal acts which the prosecutor does not intend to investigate. The Appeal Chamber notes in this regard that there is no expectation at this stage of the proceedings that the prosecutor should notify states of every act he or she intends to investigate, especially in those situations referred to the court, which cover a large number of alleged criminal acts. Indeed, in such situations, the prosecutor may be in no position to identify all potential cases that fall within the scope of a broad referral and commit so early in the process to investigating them. It is not in and of itself an error for a pretrial chamber to rely on the prosecutor's information about criminal acts with respect to which the prosecutor does not express a clear intention to investigate, as long as such information, together with other information provided by the prosecutor, provides the general parameters of the situation and sufficient detail with respect to the groups or categories of individuals in relation to the relevant criminality, including the patterns and forms of criminality that he or she intends to investigate. The Appeal Chamber also finds that the pretrial chamber did not err by rejecting Venezuela's argument that it had not received sufficient information to exercise its right under Article 18 of the statute. Venezuela further argues that the pretrial chamber erred in finding that there is no time limit for the prosecutor's application for a ruling under Article 18.2 of the statute. However, the Appeal Chamber notes that Article 18.2 of the statute does not impose any time limit on the prosecutor for his or her application to a pretrial chamber for authorization to investigate. As a result, the Appeals Chamber rejects the first ground of appeal. Under the second ground of appeal, Venezuela mainly submits that the pretrial chamber erred by exclusively relying on the English translation of selected 62 case files and failing to require the prosecutor to provide translations of material received from the state in support of a deferral request. The Appeals Chamber considers that it is a state seeking deferral that must provide translation into English or French of the documents upon which it relies to assert that it is carrying out or has carried out relevant investigations. This in order to ensure that the pretrial chamber can analyze the materials submitted in support of its assertion. The Appeal Chamber is of the view that the state concerned is in the best position to identify the relevant documents, especially where the supporting material is voluminous and the state chooses to present a selection of this material. Furthermore, the finding that the state must provide the required translations does not preclude the state and the prosecutor from engaging into a process of consultations to ensure that the documents which the state considers the most relevant to support its assertion are provided to the pretrial chamber in one of the working languages of the court. While the prosecutor does not have an obligation to translate the documents in support of a state's deferral request, he or she may provide assistance where needed. The appeal chamber also considers that having regard to the large amount of information submitted by Venezuela in its original form, it was reasonable for the pretrial chamber to invite Venezuela to focus its translation on documents deemed essential to its deferral request. Venezuela further submits that the pretrial chamber erred in law and abused its discretion by excluding in limine summaries of proceedings translated by the prosecutor, originally provided by Venezuela in Spanish, and any other documents that were not original police or court records. The appeal chamber finds that the pretrial chamber erred by failing to provide a sufficiently reasoned decision on this point. The appeal chamber notes that the impugned decision does not indicate which documents were not relied upon because they were deemed to be irrelevant, and which were not relied upon because they did not contain original records. The appeal chamber considers that the pretrial chamber erred by failing to conduct this assessment and to sufficiently explain why it decided not to rely on these documents on the ground that they were not relevant or did not contain court or police records. Having reviewed the material in question, the appeal chamber considers that the summaries or fichas have very limited probative value, and that even if it had not made the error, the pretrial chamber would not have rendered a decision that is substantially different from the impugned decision. The appeal chamber therefore finds that the pretrial chamber's error does not materially affect the impugned decision. Venezuela submits that the pretrial chamber failed to consider its submissions and to place any weight on the memorandum of understanding signed between Venezuela and the prosecutor, simply because no such memorandum had been filed before it. The appeal chamber considers that Venezuela does not explain the significance of what it intended to demonstrate on the basis of the memorandum of understanding. Venezuela has therefore failed to explain why the pretrial chamber had a duty to consider the impact of that memorandum on the pretrial chamber's Article 18 assessment. For the foregoing reasons, the appeal chamber rejects the second ground of appeal. Under the third ground of appeal, Venezuela alleges that the pretrial chamber erred by relying on the temporal scope of the situation referred to the prosecutor by 6 state parties to reach the conclusion that the temporal scope of the prosecutor's intended investigation also covers conduct prior to April 2017. Venezuela also submits that the pretrial chamber erred by finding that the incidents set out in the prosecutor's additional information were capable of curing the ambiguous temporal scope described in the Article 18 notification. The appeal chamber notes that the prosecutor's Article 18.1 notification, together with the additional information, provided Venezuela with sufficiently specific information as to the temporal scope of the prosecutor's intended investigation. The appeal chamber also notes that the pretrial chamber, in identifying the temporal scope of the prosecutor's intended investigation, examined the prosecutor's Article 18.1 notification and the additional information separately from the state's referral. Therefore, the appeal chamber rejects Venezuela's argument in this regard. For these reasons, the appeal chamber rejects the third ground of appeal. Under the fourth ground of appeal, Venezuela alleges 5 errors in the pretrial chamber's assessment of whether Venezuela was actively investigating the criminal acts referred to in the prosecutor's Article 18.1 notification. First, Venezuela alleges that the pretrial chamber failed to tailor the complementarity test with respect to the identification of a case to the particularities of the prosecutor's Article 18.1 notification. Venezuela also argues that the pretrial chamber focused on whether domestic investigations had identified particular perpetrators or taken steps to secure the arrest of particular individuals. The appeal chamber considers that Venezuela misrepresents the impugned decision in this respect. The focus of the pretrial chamber's assessment was on whether Venezuela was conducting or had conducted any investigations or prosecutions of the same categories of individuals, that is, alleged high-ranking members of the state security forces and pro-government individuals, in relation to the relevant criminality as encompassed by the prosecutor's intended investigation. The appeal chamber therefore finds that Venezuela fails to demonstrate any error of the pretrial chamber in this regard. Second, Venezuela alleges that the pretrial chamber required an unspecified degree of coverage between Venezuela's domestic investigation and the acts notified by the prosecutor, and failed to provide adequate reasons as to the basis for its conclusion that the acts investigated by Venezuela did not sufficiently mirror the alleged criminal acts notified by the prosecutor. The appeal chamber considers that the impugned decision was sufficiently reasoned. The pretrial chamber set out the criteria for its determination of whether Venezuela's investigation sufficiently mirrored the parameters of the prosecutor's intended investigation. The impugned decision indicates with sufficient clarity how the pretrial chamber arrived at this conclusion. Turning to Venezuela's contentions in relation to the prosecutor's use of samples in the additional information, the appeal chamber notes the detail regarding the alleged crimes provided by the prosecutor in addition to the samples. The appeal chamber considers that sufficient information was provided for the pretrial chamber's assessment. Accordingly, the appeal chamber rejects Venezuela's argument in this regard. Third, Venezuela alleges that the pretrial chamber erred in law by finding that it was necessary for domestic investigations to cover contextual elements of crimes against humanity. The appeal chamber recalls, I quote, that the inclusion of contextual elements as constitutive elements of the crimes allows for the identification of the legal interests provided by each provision, end of quote. Therefore, in order to pursue the legal interests protected by crimes against humanity, a state which has not incorporated crimes against humanity in its domestic law, while it is not required to investigate the alleged criminal acts under the legal qualification of crimes against humanity, must nevertheless investigate the factual allegations underpinning the contextual elements of such crimes. This includes, in particular, an investigation into the factual allegations underpinning the widespread or systematic nature of the attack, and those that may allow the conclusion that the attack was carried out pursuant to a policy. Accordingly, when the scope of the prosecutor's intended investigation, as set out in an Article 18.1 notification, includes allegations relating to crimes against humanity, a state seeking to assert its primary jurisdiction over such crimes must demonstrate the existence of an advancing process of domestic investigations and prosecutions of the facts and circumstances underpinning the alleged crimes, and do so including the factual allegations underpinning the aforementioned contextual elements of crimes against humanity that were sufficiently notified through an Article 18.1 notification of the prosecutor. As a result, if a state does not investigate the factual allegations underpinning the contextual elements of the alleged crimes against humanity that were sufficiently notified to it, it follows that it will not be able to demonstrate in the proceedings under Article 18.2 of the statute that the domestic criminal proceedings sufficiently mirror the scope of the prosecutor's intended investigations. In respect of Venezuela's argument relating to the incorporation of crimes against humanity into domestic legislation, the Appeals Chamber notes that the preamble of the statute stipulates that an effective prosecution of the most serious crimes of concern to the international community as a whole must be ensured by taking measures at the national level. The preamble also imposes on every state the duty to exercise its criminal jurisdiction over those responsible for international crimes. Therefore, while the statute does not expressly impose an obligation on state parties to incorporate crimes against humanity into their domestic legislation, such incorporation may facilitate the fulfillment of their duty to exercise criminal jurisdiction over those responsible for international crimes. Turning to Venezuela's contention that an alleged widespread or systematic attack is investigated where national authorities investigate, I quote, several alleged crimes, either in different locations at the same period or in the same location over a period of time, end of quote. The Appeal Chamber notes that Venezuela does not refer to any national investigation that compared or otherwise jointly examined findings made in the course of investigations into individual alleged crimes with a view to assessing whether such crimes were widespread or systematic. Concerning Venezuela's arguments contesting the systematic nature of the alleged acts and the existence of a state policy, the Appeal Chamber notes that for a state to be successful in seeking a deferral of the prosecutor's investigation, it is not enough for it to make a blanket statement that the court lacks material jurisdiction on the basis of the absence of contextual elements of the alleged crimes against humanity. In such a situation, the state must support and substantiate its assertions by demonstrating concrete and tangible investigating steps it undertook to reach such a conclusion. In this context, the Appeals Chamber notes that Venezuela did not provide the pretrial chamber with sufficient information as to Venezuela's domestic proceedings in respect of the same groups or categories of individuals in relation to the factual allegations underpinning the contextual elements of the alleged crimes against humanity, including the patterns of criminality. As just discussed, domestic investigations into isolated acts of detentions and physical assaults allegedly perpetrated by direct low-level perpetrators, without examining the systematic nature of their commission and without investigating the factual allegations underpinning the contextual elements, albeit the subject matter was quoted as 17,000 investigations, all these failed to address the distinct legal interests protected by crimes against humanity. The Appeals Chamber finds that Venezuela fails to show any errors in the pretrial chamber's findings in this respect. As regards the domestic proceedings concerning the alleged acts of torture and cruel and inhuman treatment associated with the arrest and detention to which Venezuela refers, the Appeals Chamber notes that none of these proceedings shows any investigating efforts on the part of the competent national authorities to explore possible patterns of criminality or connections between those isolated crimes and other similar crimes, or the existence of a policy. The Appeal Chamber therefore rejects these arguments presented by Venezuela. Fourth, Venezuela alleges that the pretrial chamber erred by finding that Venezuela's investigations needed to cover discriminatory intent in connection with underlying acts pertaining to the prosecutor's potential investigations related to persecution, while excluding domestic investigations into human rights violations. The Appeal Chamber notes that the crime against humanity of persecution under Article 7 of the statute requires discriminatory intent as one of its elements, and that it is committed, I quote, on political, racial, national, ethnic, cultural, religious, gender, or other grounds that are universally recognized as impermissible under international law, end of quote. Given the distinct legal interests protected by this element of crimes, it was not an error for the pretrial chamber to examine whether the competent authorities had investigated factual allegations of discriminatory intent in relation to the crimes investigated. Venezuela refers to the possibility of addressing matters of discriminatory intent as an aggravating factor in sentencing. However, the Appeals Chamber notes that Venezuela does not refer to any specific case in which consideration of discriminatory intent was actually used as a factor in the determination of the appropriate sentence. Similarly, the Appeals Chamber notes that Venezuela misrepresents the impugned decision in arguing that the pretrial chamber erred by disregarding investigations into human rights violations on the ground that they were not being labeled as criminal offenses, and fails to indicate any specific domestic investigation or prosecution that the pretrial chamber purportedly disregarded. The Appeal Chamber therefore rejects Venezuela's argument in this respect. Fifth, Venezuela's alleges that the pretrial chamber erred in law by excluding domestic investigations into criminal acts pertaining to sexual and gender-based violence due to its erroneous focus on whether they were being investigated or prosecuted as such. The Appeal Chamber reiterates that the legal interests provided by each crime can be discerned by reference to the elements of that specific crime, and that the interests connected by materially distinct elements are necessarily different. In the situation at hand, the Appeal Chamber considers that the pretrial chamber did not err by observing that the legal pre-qualification and conviction do not include any crimes with a sexual or gender component. To the extent that Venezuela's investigations and prosecutions examine the relevant acts as torture and cruel treatment, the domestic proceedings failed to address the distinctive legal interests protected by the crime of rape and other forms of sexual violence, and to protect the distinguishable harms suffered by victims. Furthermore, Venezuela relies on a potential requalification as rape at a later stage in the national proceedings. However, in the absence of any concrete evidence of taking such steps at present, the appeal chamber will not entertain Venezuela's hypothetical submissions in this regard. The appeal chamber therefore rejects these arguments of Venezuela. The appeal chamber therefore rejects the fourth ground of appeal in its entirety. Under the fifth ground of appeal, Venezuela submits that the pretrial chamber erred in law in its complementarity assessment by relying on irrelevant factors. For instance, Venezuela argues that the pretrial chamber erroneously relied on the number of identified suspects, the number of arrest warrants, and the rank of possible suspects. Venezuela also contends that the pretrial chamber failed to give any weight to relevant factors, such as whether the national authorities were collecting data about victims. However, the appeals chamber rejects this ground of appeal, as with respect to some of the arguments under this ground, Venezuela misrepresents the impugned decision and makes unsubstantiated arguments on the other points. Under the sixth ground of appeal, Venezuela submits that the pretrial chamber erred by excluding national proceedings from its determination on the basis that there had been delays and periods of inactivity. In particular, Venezuela argues that the pretrial chamber failed first to set out the standard for assessing delays or inactivity in the progress of domestic investigations, and second, to consider relevant factors while attaching undue weight on irrelevant factors. However, the appeal chamber notes that according to the pretrial chamber, its overall conclusion in the impugned decision was primarily informed by factors other than periods of unexplained investigative activity, which it considered to be non-determinative factors. Therefore, even if it was an error for the pretrial chamber to rely on these factors, this would not have affected the impugned decision. The appeal chamber also notes that inactivity signifies the absence of an advancing process consisting of steps directed at ascertaining whether a person is responsible for the alleged conduct. In this regard, the pretrial chamber referred to steps such as identification of suspects, the charging of an accused, and the taking of a judicial decision on an accused's criminal responsibility. The appeal chamber considers that it is sufficiently clear from these findings that the pretrial chamber understood to constitute what the pretrial chamber understood to constitute inactivity. It follows that contrary to Venezuela's argument, the pretrial chamber did not err by failing to provide a reasoned explanation in this respect. Therefore, the appeal chamber rejects the sixth round of appeal. For these reasons, and for the reasons which are stated more fully in the written judgment, the appeals chamber rejects the appeals and confirms the impugned decision. This brings an end of the summary of the appeals chamber judgment. I would like to thank my colleagues on the bench, the legal officers, and all the interns which have contributed to this decision, as well as the court reporters, interpreters, and other registry staff for their invaluable assistance today in holding this hearing. The hearing is adjourned.
All rise, veuillez vous lever.